Yes, Mr. Hogan. What is left in this appeal?
What is left in this appeal is the question of the correctness or otherwise of the order, the costs here and below, and the wider point of principle as to whether unenforceability flows from the order made of the court or the order construed against a penumbral effect of the rules read in conjunction with the order.
Well, just dealing with costs first. If an order for costs were made in the defendant's favour, it wouldn't be enforceable, would it?
It wouldn't.
So that's academic.
Well, it's the question of the claimant's costs which are an issue.
I see. Well, Mr. Marvin, do you want to say anything about whether we should hear this appeal at all?
Well, my lord, I do say it's been, I raised this point in my supplementary discussion,
yes.
I do say it's been rendered academic. It was always our case that if the rules changed in a way which, subject to transitional provisions, meant they didn't apply here, then of course we couldn't enforce. Our complaint below is that the claimants were trying to preempt that, and we didn't know about the transitional provision at the time. But we wrote, as your lordship has seen, quoted in full in my supplementary skeleton, we conceded the point about enforcement as soon as we saw the transitional provision, and I do say that there's nothing left to this appeal. And my learned friend is candid. This is all about. I mean, of course, I can't enforce my costs even if I win today, and I know that. And my instructing solicitor and my client know that. That's the reality, although it's a pity for us. So this is all about the claimant, or frankly, because the claimant's on a CFA, the claimant's solicitors wanting their costs below, and I might say their costs of this appeal, which come to an eye-watering £137,000. That's not a proper basis for the court to hear this. The substantive suggestion that the CPR doesn't apply unless its effect is in a court order.
That's getting into the merits of the appeal.
Well, I say it's academic. I won't go there. We have said, we know we can't enforce, so we're not going to enforce. Even if without going into that, we've said that openly, and I say today.
Well, you can't enforce because the rules don't let you.
Yes, exactly. And we're not going to say that because the order doesn't say we have to follow the rules, we don't have to. Whether that's so, even if that were open as an argument, we've already said we're not taking that point. So it's entirely academic. This is all about the claimant solicitors wanting their costs of the application below and their costs of this appeal.
Couple of things, if I may. I'm afraid I don't seem to have had sight of the supplementary skeleton argument.
Oh, my lord, I'm so
sorry. No, I'm sure if it's absolutely not your fault. I'm working on an electronic basis, and if I could...
Yes.
I'm sure I know what it says based upon what you just...
Your lordship does know. Does my lordship...
I've seen it, but I'm not sure that I've got it on paper. I'm sorry, but I'm old-fashioned and I work
I haven't seen it, and can I say my clerk is assiduous at chasing documents, and I know it's not in our core bundle.
No, it's not in the core bundle because it was later than that.
Yes.
I think Lord Justice Lewison has seen it because his clerk actually asked me directly for word copies of the skeleton.
I have, but I haven't got a paper copy of it. I have certainly.
I've got one. I've got one paper copy there. Let me see
if I could go over to her ladyship first, then I'll gladly read it later.
I haven't got a printed copy. I'm not quite sure what happened to it.
Well, I think my lord...
It's very short.
No, Lord Justice Lewison, please.
I wonder if I might assist. We have spare copies of both supplementary skeletons.
Thank you very much.
But you have one as well?
Yes.
Oh.
While you're doing that and thinking about it, I would also like some help, please, as a non-specialist member of the court, about what lies behind, firstly, the claimant's costs observation that you made and what the story there is. And
that's one there for each of the lordships.
So firstly, I'm sure that this is something that Mr. Hogan will be able to spell out to me how that works. And secondly, I'm just trying to recover from the suggestion that this appeal has cost £137,000 and how that comes to be. But can you help me?
Yes, indeed. If you have the supplementary skeleton argument, in Mr. Marvin's supplementary skeleton argument, he raised the issue as to whether the whether the appeal had become academic.
Yes.
And so meeting that effectively head on, and this is paragraph 13 of my own supplementary skeleton argument in response, I think the true characterization is that the defence of the appeal has become academic because, in effect, the defendant was gambling on the new QOCS provisions being retrospective, so that they would affect my client, even though his case effectively concluded on the 1st of December. But the point that I made was effectively threefold in rebuttal. The first point was that the order made by the learned judge below was wrong in principle and remains wrong in principle, because my client is entitled to an order that clearly and unequivocally records that the costs order made against him is unenforceable, because this is the principle of finality. The second point was that my client was ordered to pay the defendant's costs below. As my Lord Justice Lewison has observed, that order is unenforceable, or should be unenforceable. But the reality of the matter is that he was deprived of his costs below by reason of that order. And then, of course, when this appeal was launched, it was not in any shape or form academic. It was a point which went to a very significant potential liability on the part of my client. And of course, costs were incurred during that process. The further point, and this is the point that remains live, is this. The old QOCS rules, if I put it in those terms, remain in force and will remain in force while the tail end of cases, which were issued before the 6th of April 2023, run through to conclusion. So the provisions of the old rules and what they mean will remain live for, as matters of practice for the lawyers to grapple with for years to come. And as this court will appreciate, if one is dealing with cases involving infants, for example, or people who lack capacity, those cases may be very substantial and may run for many more years than the mainstream litigation. And of course, during the course of those years, there will be orders made for and against claimants, and there will be settlements for and against claimants, which involve cost provisions. So it is utterly crucial as to whether there is clarity, whether unenforceability flows from the court order that it's made or agreed, or whether people don't need to bother with that because the rules have some penumbral effect which lies there in the background. So that is why, in a nutshell, I say this appeal isn't academic, and there are live points here which affect not only Mr. Tabbitt, but also others who are in his cohort of cases.
Right. Shall we
could I just
Yeah.
complete this dialogue? Thank you.
Yes.
It's very helpful. But right now, so what is meant by your observation about the claimant's costs? Can you explain
Yes, forgive
what that consequence is?
My Lord Justice Lewison has already raised the fact, and it's conceded by Mr. Marvin, that the costs order below made against my client should not be enforceable. It's also conceded that the costs of the application below should not be enforceable in respect of the order made against my client. And Mr. Marvin also accepts that as a matter of practicality, because this appeal also has the benefit of QOCS protection, even were he to win his case, he cannot enforce his claim for costs. My position, however, is that the claimant has incurred substantial costs below, also substantial costs on the appeal. Can I say this? Although the claimant's costs are significantly more than the defendant's in round terms, that is because the defendant's costs are claimed at much lower hourly rates because they're underwritten by an insurance company using panel rates. And similarly, in relation to counsel's fees, there will have been a downward depression on them.
When you say the claimant's cost, do you mean since February?
Since February. Or, well, the claimant's costs since the 1st of December.
Sorry. situate that within the litigation.
Yes, because in relation to the cost order below, that effectively provided for my client to be deprived of the cost of the hearing before the judge on the 1st of December. There are also the claimant's costs which were incurred in launching the appeal in the weeks after the hearing on the 1st of December and carried through. And then there have been the costs incurred in the last 6 months, effectively.
Right, so that all comes out of Mr. Tabbitt's damages.
Well, the position is that, in effect, he would be potentially liable to my instructing solicitor unless she was prepared in some shape or fashion to forgo her costs, but as a matter of...
But it's since, you say, since the 1st of December, the judge's order.
Yes.
So that period between December and now June,
yes,
is the costs which you're meaning by the claimant's costs.
Forgive me, yes.
Right, and you were about to, in ballpark terms, just say what the figures on both sides are.
Yes, I think they're just under 50,000 for the defendant.
For the defendant?
For the defendant. And for the claimant, I think they're about 137,000.
Nearly 3 times.
Yes, but there is the discrepancy in hourly rates, my lady. I should also say that there have been other incurrences of costs along the way, in the sense there's been a mediation, of which I'll say no more, but there have been things undertaken.
That's what I wanted to ask, thank you.
Right, well, we will rise us for a couple of minutes and see where we are. Don't go away and don't leave the court. Please.
Court rise.
Mr. Hogan, Mr. Marvin, we will hear the appeal.
Obliged. My lords, my lady, if I might invite the court to look at the order in question, which is at page 40 of the appeal.
Yes.
What I would propose to do is to divide my submissions so that I take the court to the law, including the authorities, the judgment of the learned judge, and develop the grounds of appeal. But before I start upon the first of those points, can I just give the court, please, some threads or an overview as to the issues at stake in the appeal? As a general principle, the defendant has no right to costs against my client and no mechanism for getting costs from my client, unless and until the court makes a costs order against my client. The defendant's entitlement to get costs, the mechanism for doing so, can only flow from such an order. Under Section 51 of the Senior Courts Act of 1981, when any costs order is made by this court or the court below, it is exercising a statutory discretion as to which party the cost order is made against, which costs it relates to, what part of the proceedings, and the extent to which costs are to be paid against the person the order is made against. And that question of extent includes notions or concepts of enforceability or unenforceability. The order at page 40 is also a sealed final order. It can only be challenged by way of an appeal, or corrected by use of the slip rule, or possibly varied under Rule 3.17 of the Civil Procedure Rules. But on the face of that order, the defendant is given the costs of part of the proceedings, but there is no bar in the terms of this order on the defendant enforcing the cost order after they have had their costs assessed.
Say that again?
There is no bar on the
No.
face of this order to the defendant enforcing their entitlement to costs after the costs have been assessed.
Well, there wouldn't usually be any such thing, would there?
There usually would be.
Leave aside questions of personal injury. If A sues B for damages for breach of contract, and judgment is entered for whatever it is, £500,000, the judgment doesn't say, well, you can get a charging order or a third-party debt order or whatever it is. That's all down the track.
It is. But I think there are 2 points that I would make. The first is that in personal injury cases, the matter is treated differently because the QOCS rules are effectively unique to personal injury cases.
So it has to be treated differently.
Has to be treated differently. The second is that there is a practice of dealing with enforceability in the terms of the order. I say that, not wanting to give evidence, but I'll simply take the court in due course to 2 decisions of this court, whereby the decisions under appeal involve provisions about enforceability or unenforceability in the terms of the order they were dealing with. Now, it is right, and the court has already noted, that the effect of the QOCS provisions in force on the 1st of December 2022 was that the defendant should be unable to enforce its claim for costs against my client. But that leads to a difference of approach or principle, which, my lord, you've already identified in your last question to me, namely whether the order should record the bar of enforceability on its face. Because the position that I adopt on behalf of the claimant on this appeal is that the judge not only should have given effect to the QOCS rules when making this order at page 40, that was the only order that she could make when applying the QOCS rules in the factual matrix of this case. Now, the issue of principle between myself and Mr. Marvin for the defendant is that certainly his position below, and I understand to be the same on this appeal, is that unenforceability doesn't need to be reflected in the order. It exists by way of a penumbral effect of the order, construed against the version of the QOCS rules then in force. In a nutshell, unenforceability comes from the rules, not the order. Now, my counter to that is it's simply wrong. There is no such penumbral effect. Rules are given effect by orders. The reader of this order could not know that it was unenforceable on Mr. Marvin's case unless they further knew that this order, first of all, related to a personal injury.
Can I just question that last proposition?
Yes.
You say rules are given effect by orders. I would have thought that orders are given effect by rules.
No, if I can refine that, my lord, what I would say is that the QOCS rules contain the criteria which determine which order should be made.
Can I tease out 2 other things here? It's open, one might think, for a judge to make an order for costs and say that this order for costs is not to be enforced. For example, without the leave of the court, it might be a football pool's situation, or it might be some other reason why the judge was prepared to make an order but in effect suspend its enforceability, just as a case-specific order. That's not what you were asking should happen here. You weren't saying there are circumstances in this case which means that you should exercise your independent power to make the order unenforceable. What you were doing, I'm reading from various points, but in your appellant's notice here, was you were saying, pursuant to 4414, the defendant is not permitted to enforce. So what you were asking for was you were asking to have the rule put on the face of the order.
I think
with your interpretation of what that consequence would be.
I think two points, my lord. The first is that I attributed no particular significance to the form of word used, provided there was a bar on enforceability. The second is that the actual wording sought was that reflected in two orders in two other cases.
Fine, but are you accepting that there's a distinction between a judge just saying, exercising the overriding objective and all other manner of good things, I'm going to reach this conclusion on the facts of this case, I'm going to make the order for costs, but say it's not enforceable. That's one state of affairs.
Yeah.
And another state of affairs is to say, I'm making this order for costs, but everybody knows that as a result of Rule X, it's not enforceable. Those are different things, aren't they?
They are conceptually different, my lord.
Yes. You weren't asking for the first.
I was. And can I explain why?
You were.
I was, yes. Because when the court makes an order for costs in the High Court, it's Section 51. Section 51 gives the court a very broad discretion, but it's subject to any enactment or rules of court which would have bearing upon the court's discretion. So my position below, and the one I adopt on this appeal, is that when a judge is making an order in a context of a case like Mr. Tabbitt's, QOCS effectively puts the judge in a straitjacket in terms of her discretion, because in effect there was only one order that could be made, that the costs order would not be enforceable. So it's to return to your question, my lord, the source of the power is the discretionary power in Section 51. But because the rules are drawn so tightly in the QOCS rules, there was only one right order that could be made.
Why does it follow that you then have to make a reference to the specific provision? If Section 51 says, as you say it does, that it is a discretion to be exercised, but in my words, it's in accordance with the rule of the court. Why is there the imperative you're suggesting to specify the rule? It's lawyers who are going to be looking at this.
Yes. I think there are 2 points that flow from that. The first is that there is not actually an imperative to specify the rule, provided that the words, the order is unenforceable, are there to that extent, because that's the effect of them. The second point, which flows from my lady's question, is this. It is quite correct that there are lawyers who are going to be principally dealing with these orders, but there are 2 points that flow from that. The first is that it is a public document, therefore anyone could be tasked with looking at this order to determine what it means. The second consequence from that is that in order to know that this order is unenforceable, if the respondent's position on interpretation is right, you then have to know certain other facts. You have to know that this is a personal injury case. You have to know the date the proceedings were issued, because that deals with which set of QOCS rules you're dealing with. And thirdly, you have to know what the QOCS rules say in order to know whether it's enforceable or not.
Can I just pick up a point you made by asking a slightly different question from the one that Lord Justice Peter Jackson put to you? You said that the QOCS rules are so tightly drawn that they put the judge in a straitjacket. Now, imagine personal injury proceedings launched after April 2023, and imagine that as Lord Justice Jackson put to you, the judge takes the view that on the facts of a particular case, an order shouldn't be, a cost order shouldn't be enforced without leave. Do you say the QOCS rules as they now stand are so tightly drawn the judge can't make such an order? And if you don't say that, why not?
Well, if one looks at the QOCS rules as they now stand, and can I take the court to the White Book?
Yeah.
2023. It's page 1413, the start of section 2, qualified ordinary cost shifting.
Yeah.
44.13 is the scope and interpretation section.
Mm-hmm.
The amendments are in 44.14.
Yes.
And what they do effectively is this: whereas the old version of 44.14 limited enforcement an order for damages and interest, which in practical terms meant judgment obtained at trial, this has expanded it out to any orders for damages or costs or settlements, so that the pool is much more widely drawn. So in relation to the way that QOCS works, it continues to be a mechanistic process, but it simply means that the gateway through which a defendant can enforce their costs in this particular part of the rules has been widened. But it would not go to creating a freestanding discretion to say not to be enforced without leave for factors A, B and C which aren't contained within the QOCS rules, because the effect of that would be to erode the gateway that the defendant has been given by the rules, which really means that they can enforce without needing permission of the court, without needing the court saying they can, as a point of merit, provided as a question of fact there is money in the damages pot or money in the cost pot.
I think the answer to my question is no. The court could not, on the facts of a particular case, say that an order shouldn't be enforced without leave.
Exactly so. So I then come back to a final thread which is running through the appeal, which is the principle of finality. Because this being a final order at page 40, the case effectively came to an end there, but for any questions of quantification of costs. And that, in effect, is simply working out what the cost orders mean. So if one then looks at it in terms of where the defendant's argument takes matters, the defendant's position, and indeed the strategy that they're employing in this case, was that it would be possible for such an order to shift and mutate in its effects. An order would be unenforceable on the 1st of December, but if the QOCS rules had changed without the transitional provision, then the order would have been enforceable from the 6th of April 2023 or whenever the new rules came into being. Now, the difficulty with that is...
How does that differ from a football pool's order where the defendant or the claimant does actually win the football pools? He didn't have money at the time, so there wouldn't have been enforced, but now he does.
It's different in terms of the tightness of the criteria. The legal aid provisions under the football pools were much more nuanced because they reflected that there are at least 4 different orders you could get. And winning the football pools would be a material change in circumstance which would then trigger the leave provisions. But in the QOCS rules, there's no issue about, for example, financial means, even if the claimant did win the football pools.
Oh, yeah.
It's not means related.
Yeah. On the question of finality, that is a principle that applies across the board. It's not just in personal injury cases. So, is the logic of your argument that in a claim for damages for breach of contract, the court ought to engage at the point of giving judgment with methods of enforcement? And if not, why not?
The reason for that is that, in effect, QOCS represents a balkanisation of personal injury litigation. Because it's such an inherently tilted playing field between injured individuals and large corporate or state actors, QOCS represents a departure from the norm. So, in a sense, QOCS could be viewed as a quantum realm where the normal principles of litigation are modified. So, what I say, just building on the point my Lord just raised, is that if one follows the respondent's position through, if the QOCS rules had changed and had been retrospective in their effect, then they had the potential to upturn, or at least to adversely affect, settlements reached for years before the implementation of the new rules.
Was there anything to prevent when your client finally came to decide to wish to accept the offer that had been made some time before, there being an agreement between the parties in accordance with what you and I are seeking?
The answer to that is there could have been such an agreement in the sense that it could have been reflected in correspondence.
Yes.
Where you'd have an argument collateral to the order, but it wouldn't be contained in the order itself. The second point, which is
the deal would then have been X 100,000 and you don't enforce. So it's perfectly open to a claimant and the defendant to agree some such arrangement.
Yes, yes.
But that's not what happened in this case. You instead accepted and then argued.
Yes, and their position was that at that time they weren't going to do anything other than move to enforcement if the rules changed and the rules changed in their favour.
Yes, but that was after
yes.
the offer had been accepted.
Yeah. Yes, and there's a further point, however, which it is of significance. The order itself is a piece of property. As such, it's capable of assignment and it can be inherited by others. And can I give you two examples of that, my Lord? The first point is that the practical beneficiary of any order is the insurance company who stands behind the nominal defendant. But insurance companies can change over the years. They can be taken over, they can be reorganised, their assets can move from one company to the other. So you then have a situation as to whether any collateral agreement would bite upon the actual order which has been assigned. The second scenario is that you can have a situation whereby debt is purchased by organisations, which includes court orders, judgment debts and so on, at a discount. Then the assignee of the order or judgment debt seeks to enforce it for whatever they can get.
I understand that, but it doesn't seem to deal with the point that I raised with you, which is that, had there been an agreement in accordance with what you were wanting, then none of that could make any difference to that agreement, because that's what would be underpinning the court order.
Yes, and I think the answer, coming directly to the point my Lord is raising with me, is that there was no prospect of an agreement of that nature. The defendant had a strategy that they were going to move to enforcement if the rules changed. Hence, we had a period between, I think, November and the 1st of December, where there was various correspondence, where they were giving reasons why they wouldn't.
There were risks either way. You could have said, fine, you're not going to accept that, we'll take you to trial. And they may have ended up paying twice as much, and all your costs. But that's not what happens. There was a deal.
There was a deal.
Which you then tried to sweeten with your application in November.
Not entirely, because the position that we adopted with the application that was made was that the usual orders which were made were those which were reflected in Part 36. You get your cost at 21-day point, and they get their cost thereafter. the position that we adopted was that that order was in a sense nugatory because it couldn't be enforced. Therefore, there should be a term in the order which reflected the fact it couldn't be enforced. Now, the defendant refused to put a provision to that nature into the order because they took the view that it would bar them, and it would bar them, from running the argument on retrospectivity if the rules changed in a particular fashion which favoured their position. But the other aspect of finality, coming back to my Lord Justice Lewison's point, is that what the judge should clearly have done is apply the law as it stood on the 1st of December. And in her judgment, she expressly says that she's not going to make the order. And one of the reasons for that is because the law may change at some point a little further down the line. So,
Well, in what sense was she applying the law?
well, in relation to the law, she has to make a costs order. She has to exercise her power under Section 51, subject to the rules of court, which are the QOCS rules. And the QOCS rules, as at the 1st of December, allowed no possibility of enforcement. So the only order that could be made...
She's not applying the law. That's what the rules say.
Yes, but she has to determine what the extent of her discretion is, what the relevant criteria are, and then make the order which flows from that exercise.
And I mean, you accepted a Part 36 offer. That's how this claim came to an end. And Part 36 describes itself as a self-contained procedural code.
It does.
And you want to modify that code by your declaration.
No, I don't. Can I explain why? If one turns to the relevant rule in Part 36, in the part, in the white book,
Yeah.
it's rule. It's page 1174.
Yes.
That deals with 36.13, which is the cost consequences of acceptance of a Part 36 offer. And this contains the normal 21-day provision, which I mentioned in relation to my Lord Justice Jackson's query. If, however, you look at 36.14 and sub-rule 5 on page 1177, you'll see that that provides that any stay arising under this rule, and of course the claim is stayed once the notice is served, will not affect the power of the court to enforce the terms of the Part 36 offer or to deal with any question of cost.
Right.
So that preserves the court's general discretion under Section 51, subject to modification. So, my Lord, moving on to the law, if I may, and taking up the authorities matter. If I start with Section 51 of the Senior Courts Act at tab 1, you'll see there how this is structured. Subsection 1 of Section 51 is the doorway through which QOCS comes into the room. It says, subject to the provisions of this or any other enactment and to rules of court, the costs of an incidental to all proceedings lists the court and makes the point that it's in the discretion of the court. Subrule 2 is concerned with specific powers of the rule-making body to make rules dealing with various aspects, and that perhaps doesn't concern the court. On this appeal, but subsection 3 does, because it says the court shall have full power to determine by whom and to what extent the costs are to be paid. And the wording extent includes concepts of enforceability. If I can then take the court to tab 2, you have the QOCS rules as they were on the 1st of December, extracted from the white book.
Yeah.
And rule 44.14 is significant because it's that rule, as the court is aware, which read with Cartwright and Adellica.
Sorry, which rule are you looking at?
Forgive me, my lord, it's rule 44.14 sub rule 1.
Yes.
It is that rule which read with the Court of Appeal judgment in Cartwright and the Supreme Court judgment in Adellica, means that cost orders are only enforceable up to the limit of orders for damages and interest, which in this context will mean practically an order made at trial. 44.14.2 on the next page is significant because this is relied upon by the defendant in the argument. What that says is that orders for costs made against a claimant may only be enforced after the proceedings have been concluded and the costs have been assessed or agreed. Now, the interpretation that I suggest or submit is pertinent to that rule is that it's concerned with timing as to when enforcement takes place. It's not concerned with the principle as to whether there should be any enforcement. And the most obvious application of the rule is in its application to interlocutory cost orders made in the time where the case is proceeding through the courts. And in effect, even if an interlocutory cost order is made against a claimant and the costs are summarily assessed as they usually would be, that rule would have the effect that it would bar enforcement of the costs even even though there's a quantified sum. Now, simply by way of example, in this case, in the supplementary bundle is an order made against the claimant, Mr. Tabbitt, by the same judge who made the order at the end of trial. And it's at page 39 of the supplementary bundle. This is Her Honour Judge Walden-Smith, sitting as a Section 9 judge. And the actual text of the order deals with, effectively, directions for trial, listing for trial. But there was an application made. And if one turns to the second page, page 40, you'll see that in the final paragraph, the order made by the judge was that the claimant shall pay the defendant's costs of an occasion by reinstating the trial date, but subject to the provisions of one-way qualified cost shifting, and then a quantified sum was given. So the significance of that sentence in brackets was that the intention of the judge was to bar enforcement, immediate enforcement of that sum, and it was understood to have that effect. Now, it may have been possible to word that differently, but everybody knew what it meant. Now, if I come back to take the court through the QOCS provisions before turning to the authority.
Sorry, what do you say it does mean?
What I say it does mean is that there is to be no enforcement because it references back to the relevant rule in the QOCS rule.
At all?
No enforcement at that time.
At that time, because that's what the rules say.
Exactly. Yes.
But it doesn't preclude enforcement later on, does it? Or do you say it does?
It would have precluded enforcement unless there was an order for damages and interest.
Well, suppose it gets to trial and the judge decides the claimant has brought a fundamentally dishonest case. Then what? You can enforce?
Then the judge will make an order that the costs are enforceable against the, well, make an order that the costs are enforceable against the claimant, but doesn't need to put anything in the order because it simply says claimant pay defendant's costs on the indemnity basis.
The defendant would then go back to this order that we're looking at and say, well, this is all subject to QOCS. The claim has been found to be fundamentally dishonest. That means QOCS says I can enforce, so I can enforce.
Well,
Is that right?
There would be 2 points. The first is that the order would potentially be varied. But secondly, the better interpretation is that because it's subject to the provisions of one-way qualified cost shifting, you would simply follow through the logic that the case having been found to be fundamentally dishonest, everything's enforceable.
Yes, that's what I would have thought. So you look to the rules.
You look to the rules, but the rules are brought into play by the order. If I move to 44.15 and 44.16, just to make two very brief points. 44.15 deals with strikeouts and the consequences of strikeout. When a claim is struck out on the basis that there were no reasonable grounds for bringing the proceedings, or there's been an abusive process, or there's been conduct likely to obstruct the just disposal of the proceeding, then the position is that the defendant should be able to enforce the last order. And so the order will simply provide that the costs should be paid by the claimant to the defendant. There won't be a bar in the order on enforcement. What the court will see is that one of the common bases upon which a court may strike out a case for breach of a court order, breach of an undue order, or something of that nature, is not contained within 44.15. And that is deliberate. The wording of the rule is such that if there's been these extreme categories of litigation behaviour, then the policy objective is the claimant should lose their QOCS protection. But if they just fail to get their witness statements in on time and their case is struck out, that is a procedural default, and there is no scope and no power here for the court to make an enforceable cost order against the claimant. There has to be more. So in those circumstances, an order might be drawn in one of two ways. The first is that if it simply says claimant's claim is struck out, then one would be in the position that in order for the cost order that is going to be made following that, there needs to be a bar on enforcement, because otherwise it is not apparent what the position is in relation to enforceability. The other way that it could be done...
Well, 44.15 is dealing with circumstances in which a case never gets to trial.
Never gets to trial.
And it is premised on the concept that the claimant never recovers any money, because his claim never gets to trial and it hasn't settled, it's been struck out.
Yes.
So when we're talking about enforcing cost orders against the claimant,
Yes.
that is against the claimant's personal assets, so to speak.
It is.
Not against any fund which has resulted from the proceedings. It could be against his house or whatever.
Yes, but that would be the same under 44.14, because the wording of 44.14 is up to the aggregate amount of the damages and interest. It's not a proprietary right.
Hang on, follow.
Right.
But under 15,
Yes.
you just look at whatever the claimant's got.
You do. But again, the position is you will have strikeouts whereby the claimant loses their QOCS protection, and you'll have strikeouts where they don't. Therefore, the cost order needs to be clear as to whether they're going to be enforcement is permitted or not. It's the same point, really, in 44.16. My Lord, you've already raised the example of fundamental dishonesty with me, but the other example, other category of claim in 44.16 is what is sometimes colloquially referred to as the mixed claim. And a mixed claim, to take an example, would be a road traffic accident where there's damage to the claimant's person and damage to the claimant's motor car. The damage to the claimant's person attracts QOCS protection, the claim in respect of the motor car does not. And in those circumstances, the court has a discretion as to whether the claimant loses QOCS protection, and if so, to what degree. And following through, if the claimant's claim was really a personal injury claim and the property damage claim was the add-on, the answer may be, as a matter of discretion, the claimant doesn't lose QOCS protection at all, because the contribution to the costs of the property damage claim is so small. But that, again, would require the court to make an order specifying to what degree, what percentage often a costs order in the defendant's favour is enforceable against the claim. So, my lords, if I can move away from the rules to the authorities, and I would like to start with the case of Parr and Smith at tab 5, before moving on to the more modern cases dealing with QOCS themselves, to really draw some threads on the history of this and how it's evolved as a matter of practice and principle.
It's actually tab 4.
Forgive me. Yes. If you have Parr and Smith there,
Yes.
What you'll see is that the facts of the case are far removed. Involved a right-of-way dispute in Norfolk some 30 years ago. Both parties at some points in the litigation became entitled to legal aid certificates. Therefore, the provisions of the Legal Aid Acts and the Civil Legal Aid General Regulations of 1989 came into being. But the significance of Parr and Smith is that it's an example of how the court's general discretion under Section 51 was subject to provisions of a particular enactment, which was the Legal Aid Act of 1988 and the regulations of 1989. And the effect of those statutory provisions were to prescribe and limit the cost orders that the court could make under Section 51, where a losing party had the benefit of legal aid. But the point that I put before the court, and this is the first of a succession of authority, is that the unenforceability provisions of the Act were given effect by the cost orders of the court. Insofar as there was no shield prescribed by the Act and the regulation, then the order should have been made in terms which on their face would be enforceable. If I take the court, please, to page 1036, paragraph J. This is an excerpt of the judgment of the Master of the Rolls, Sir Thomas Bingham, and at the bottom, he talks about the effect of Regulation 129. And what he says is that Regulation 129 governs the orders which the court may make. And there, if I just pause, you'll see that there were a palette of orders which were open to the court to make because of the effect of Regulation 129. Over the page, at the bottom of page 1037, paragraphs H and J, through to the top of 1038, the Master of the Rolls again talks about the cost orders that were made. In effect, the judge had made an order that costs not to be enforced without leave.
Sorry, what was the order the judge made at trial?
The judge made an order not to be enforced without leave.
Right,
but he
we
didn't.
got that at 10:33, I think. Judge
Yes.
Head.
Yes, that's correct. But he didn't distinguish between the dates before and after the legal aid certificates were granted.
Yes.
So, bearing in mind that the order didn't differentiate between pre and post granting of certificate, at 1037 paragraphs H and J, the Master of the Rolls says this wasn't the correct order. There was no ground for ordering that the costs incurred by the PARs before each of the Smiths respectively become legally aided should not be enforced. And then he makes the point that the issue of the dates was significant for the taxation. And then, going on to the top of page 138, he describes the orders which could be made, again by reference to the criteria contained within the regulation. And then sets out what the judge had plainly not ordered before concluding in paragraph CD on page 1038 that the order made by the judge was in the form expressly contemplated by regulation 129B. And that provided in A that the payment under the order for costs be suspended until such date as the court might determine or indefinitely. So Parr and Smith is significant because we see here the genesis of the principle that the provisions, criteria dictating enforceability or not are contained in the Act and the statutory instrument, but they're given effect by the order of the court. And indeed, the Court of Appeal was tasked with whether the order made correctly reflected the criteria contained within the regulation. Moving forward in time, the Jackson report is very clear that the QOCS rules and the principle of qualified one-way cost shifting is inspired by the Legal Aid Act and the provisions there.
Yeah.
But of course they're very different in terms of the effect that they have. And if I take you to the case of Wagoner, which should be at tab 5,
Yes.
You'll see here that this was the first, really, of the QOCS cases to come to the Court of Appeal. And the facts of the case were relatively straightforward. Ms. Wagoner had been unfortunate enough to have a skiing accident. She therefore sued, as the defendant, the company that had provided her with the skiing holiday, and then the company, a third party, the ski instructor, who was said to have given her negligent tuition, leading to her accident. And His Honour Judge Hughes, Queen's Counsel, conducted a 7-day trial before effectively dismissing the claim. But you'll see at paragraph 4 of the judgment, page 1970, using the internal numeration, the terms of the orders made by the learned judge. And he provided that he dismissed the claimant's claim against the defendant. Therefore, of course, he dismissed the defendant's claim against the third party. He gave a judgment on costs after receiving written submissions and refusing an oral hearing. And he ordered that the claimant should pay the defendant's costs, but that such order was not to be enforced against the claimant pursuant to the provisions of Rule 44.13 and 44.14. And then went on to say that the defendant should pay the third party's costs, but that such order was not to be enforced against the defendant pursuant to the provisions of 44.13 and 44.14. Now, when the issue went to the Court of Appeal, it was actually the second limb which was fairly in the firing line, because the point being made by the insurers, effectively, of the ski instructor, was that QOCS was not there to provide for cost protection between insurance companies. It's there for injured individual claimants. But what was ventilated in the Court of Appeal as a necessary precursor to whether that order had been correctly made was the vires or ultra vires nature of the QOCS rules and how they're given effect when the court makes an order. So if you look, please.
Just before we embark upon this, the topic of this appeal was not whether it was or was not right for him to have made order A in paragraph 4. That was not what the appeal was about.
No, effectively it was a battle between the defendant and the third party.
Yes.
The position was that the claimant had been funded not by a conditional fee agreement, but by legal expenses insurance. So the QOCS rules undoubtedly apply, as there was no pre-commencement funding arrangement, which would have meant QOCS did not apply. So it was dealt with under the new rules rather than the rules pre-1st of April 2013. But the key provision is that what was being suggested was that the QOCS rules were ultra vires, section 51, and had no effect.
Yeah.
That, however, was rejected by the Court of Appeal, Lord Justice Voss, as he then was, effectively finding that they were vires and then explaining how they took effect. And the key paragraph, my lords, my lady, is paragraph 27 on page 1978. So if I just pause there while the court reads that and then make a couple of points consequent to it.
Yes.
The first point is that the Court of Appeal finds that the QOCS rules are relevant rules of court, properly made, enforceable, which are brought in to the exercise under section 51. So they are brought in through the gateway in section 51.1. The second point is, of course, that once they are part of the criteria that have to be taken into account under section 51.1, then when the court exercises its power under section 51.3, looking at who pays the costs, what costs they're paying, and the extent to which they're paying them, then those criteria must be applied when the order is made. So on that basis, when the court considers who pays the costs, well, QOCS has got nothing to do with that really, because it's a question of who's won or who's lost, what the issues are in the case. In relation to which part of the proceedings they relate to, well, QOCS has got really nothing to do with that, because that will hinge upon the degree of success or not success. But on the question of the extent to which the costs are to be paid, QOCS is directly and uniquely involved because it restricts fundamentally the extent to which the costs can be paid. And that must be reflected in my submission in the court's order. Now, if I then move on to another case, which is at tab, forgive me, tab 9, that of Harrison, University Hospital of Derby and Burton, NHS Foundation Trust.
Yeah.
A relatively recent judgment of the Court of Appeal. The issue in the case was this. In the course of a clinical negligence claim, a substantial clinical negligence claim, the defendant made a Part 36 offer, and nearly 2 years later the claimant decided to accept that. And if the claimant had simply been able to accept the Part 36 offer, then Cartwright and Delican would have been, and there would have been no possibility of enforcement. But because the claimant had been in receipt of social security benefits, in the intervening period, she had to come to court to get an order for permission in order to accept the Part 36 out of time. The defendant, at first instance, before the Deputy High Court Judge in Manchester, says there is now an order. The order records how much by way of compensation you get. That is an order for damages and interest. Therefore, these costs are enforceable. The deputy says, no, there is a Part 36 settlement here. There is no award of damages and interest. It's simply a procedural mechanism. Therefore, the costs should not be enforceable against, the defendant's costs should not be enforceable against the claimant. And then the matter went to the Court of Appeal as to what is an order for damages and interest. But if I can invite the court, please, to look at paragraph 9, which is part of Lord Justice Coulson's judgment, who gave the only substantive judgment in this case. And if I just pause, there's a couple of points I want to make in relation to that. So the order made by the deputy was that there should be no set-off or enforcement of the costs order against the claimant pursuant to Rule 44.14, which, as Lord Justice Coulson observed, preserved the claimant's QOCS protection. But if that order hadn't been made, then the defendant would have moved for enforcement. And secondly...
I don't understand that.
Well, because they were... The
Judge Sefton was being asked, does the fact that I have given permission for this Part 36 offer to be accepted and I've adjusted it by deducting some benefits, does that mean it's no longer a Part 36 offer, in which event, yes, you can enforce? Or is it still a Part 36 offer, in which case you can't enforce? And he said, I'm bound by authority to say it is a Part 36 offer, therefore you can't enforce. So all he was doing was interpreting the rules as they stood at the time in the light of what had actually happened.
He was, but going then on to make an order.
Yes, but if he had decided, if he had simply said, this is a Part 36 offer, and left it at that, the order would not have been enforceable because the rules would have precluded it.
Well, that is the defendant's case. But my point is that when you look at how the rules are given effect, the rules are brought into play under Section 51. Section 51 is concerned with the making of a costs order, the extent of the costs order, and therefore the court has to determine as part of the costs order the extent to which my client actually has to pay the cost, whether they're enforceable or not. But to come back to the point that, my lord, you raised initially, if Judge Sefton had not put that provision in the order, on its face there would have been an unqualified absolute order for the defendant to have their costs for the relevant part of the proceeding. And one would then have had to go through the procedure that the defendant suggests, that you need to then look to the rules in order to understand what the order means. In my submission, that is wrong in principle. Can I also then deal finally in terms of the authorities with the case of AIC Limited, which is at tab 8 of the bundle. Which deals with a judgment of the Supreme Court and some expressions and considerations on the principle of finality. Now, this is enforcement of an arbitration in the international context. The facts are a million miles removed from the facts of this personal injury claim. The significance of the judgment are the principles and expression of principles upon the principle and concerning the principle of finality. And in particular terms, paragraph 35 of the judgment is significant because, as my Lord has already observed, finality is a much wider principle than simply applying to court orders. It's given rise to doctrines such as the rule in Henderson and Henderson, and there are other instances where finality comes into play. And the particular aspect of the principle in this case was the basis upon which a court could or should vary an order that has been made but not sealed at the time that the reconsideration is sought. In paragraph 35, the point being made here is that in terms of the order made, they give a very high degree or high significance to the principle of finality to court orders which are final. And they express in clear terms the limits by which a final order can be revisited after it has been sealed. In effect, any liberty to apply in the order, the application of the power in 3.17 to vary or revoke, but that's subject to its own stern criteria, and the slip rule to correct it, and then ultimately, of course, the issue of appeal.
But this is a different point. What the question for the Supreme Court in this case is, I, judge, have made an order in a particular form. Can I now, or should I now, change it? And that's what finality is directed at. It's not saying, well, finality is not the same as comprehensiveness. Put it that way. It's not saying you've got to deal with absolutely everything that could possibly arise following the trial, because other things may well arise, not least the assessment of costs, the enforcement of orders, and all the rest of it, committal to prison for breaches.
Yes. Can I develop the submission this way? Because the way that I would put it is this. If the court accepts, as in my submission it must, that section 51, the power to make a cost order, is concerned with the extent to which costs are payable, then the court has to consider it when it makes that order. The second point is that when that order is made, it is a final order, the judge's functus officio.
Yeah.
It's not going to be revisited. So it crystallises and locks in the effect upon my client so that he can order his affairs in whatever way seems good to him, and there is certainty in the process. The third point is that if the extent to which the costs are payable is to be determined when the order is made, but then shifts and changes because penumbral rules may shift and change on the basis of being retrospective, then it undermines the principles of finality and certainty. Because let me again follow this through hypothetically, because this is where the logic of the defendant's case leads them. If they were right, we would then have a situation where, as at the 1st of December, Mr. Tabbitt's case is concluded, he knows the extent of his cost liability, it's been crystallised in an order, But if the rules change and they are procedural rules which are retrospective, then that is wiped away and he's in a position whereby the costs are enforceable against him simply and effectively by a side win. It's also the case that it's, of course, not just Mr. Tabbitt, it's anyone else who may have settled their case on a particular set of assumptions. So when you come to a costs order, because Section 51 requires the court to look at the extent to which it's due, it must look at the extent to which it's payable as at the 1st of December 2022. And if it doesn't, then the issue of extent of payment is effectively left free-floating and in the rules, which is antithetical not only to formality, but also the rule of law, namely that there must be an end to these proceedings. So if I leave the authorities and take you to the judge's judgment in the appeal bar,
Yes.
I have sidebarred in my copy paragraph 19 onwards, which is at page 48 of the bundle, because that's where the judge starts her reason.
Yes.
And the point is, in paragraph 19, she accepts that the court has jurisdiction to make additional orders with respect to costs, but there is no requirement for the court to do so. Now, there, she's talking about enforceability, extent. That's what she means in context. She then goes on to make the point in paragraph 19 that the Civil Procedure Rules 44.14 set out what the current position is with regard to enforcement. Orders for costs may only be enforced after the proceedings have been concluded and the costs have been assessed or agreed. Now, it therefore follows, in a nutshell, in paragraph 19, she should have followed the logic through to bar enforcement, because that was what the position at the date the case was decided by her. But she doesn't, and she doesn't do so really for two reasons. The first point, in paragraph 20, she says, well, we're not yet at the stage of enforcement. That is both true and false. We are not at the stage of enforcement in the sense that money has to change hands. We are at the stage of enforcement in determining the principle of what should be enforced, or should it not be enforced. That was the issue. Then she goes on in paragraph 21 to talk about retrospectivity. And then in paragraph 22, she says the order should remain silent with respect to Rule 44.14. The rule is what it is and will be applied in the wording of that rule at the relevant time. Paragraph 23, she distinguishes the football pools order type case because that is an order which can be subject to change based upon a change in circumstance or some other reason. But that is to miss the point. The QOCS rules are different, they're mechanistic, they're very limited, and it's those rules that she should apply rather than to say because the defendant would be better off under legal aid legislation, that she shouldn't apply the rigour of the QOCS provision. And then paragraph 24, the order that the claimant is seeking is to lock these parties into the rules as they're currently worded, namely protecting the claimant from enforcement. Yes, 100 times yes, that's exactly what I was seeking to do, because enforcement and extent was to be determined when the case ended in a final order. And then in paragraph 25, she gives the other reason as to why she won't make the order I seek, because it's not for the court to cast the rules as they're currently worded into stone, so that if there were to be a rule change that had retrospective effect, that rule change could not take effect in the way that was intended. She is looking forward to a possible prospective change in the law, which will benefit the defendant, and that she must not do. This was a final order, and it should have been made as the law stood on the 1st of December.
Can I just I don't quite know where this leads, but the judge's part in this case was really very, very limited. The parties had taken away from her what the correct amount of damages for your client was. So they'd agreed that themselves. There'd been no trial. She didn't have any power to either say that's a lot or that's a little. She was simply making an order reflecting an agreement. It wasn't a case in which she tried it out and was making orders for costs within the rules and whatever discretion she may or may not have possessed. She was responding to your specific November application. That drew forth one bad answer from the defendants, namely she had no power, and then the answer which is now contentious, which is she wasn't going to exercise it. But I mean, why should the judge have answered your question? You could have got an answer, you could have done a deal with the defendant, but you didn't. I mean, you say they would never have agreed to it. Fine, but that was your choice. You went ahead and you agreed a settlement of the case. I'm not understanding at the moment the argument that the judge was then obliged to do anything.
There are two answers to that. Let me deal with the first point. The damages issue, as my Lord has noted, is taken off the table because the parties have agreed that.
Yes.
In relation to the cost order, it was agreed who should pay.
Yes.
In relation to the cost order, it was also agreed the dates
Yes.
by which they should pay. What was not agreed was the issue as the extent to which those costs should be paid. Because although the defendant accepted that at the time they couldn't practically move to enforcement, their entire strategy and constructed argument was on the basis they wanted a reservation, effectively, so that they could move to enforcement if the rules changed at some prospective point and in their favour. So the judge was asked to rule upon the question of costs as to whether the cost order in the defendant's favour should be enforceable to any given extent. That's what she was asked to rule upon. One then moves to the question of, well, what's the source of the judge's jurisdiction to do that? And it's only to be found in section 51. If one is then in the position where, as section 51(3) says, the extent to which the costs are payable is within her discretion, but subject to rules of court, one then moves to those relevant rules of court to see what leeway she has, either to say, yes, these costs should be enforceable, or a plague on both your houses, I make no order, or is the only order that she can make consistent with the rules of court that the costs are not enforceable. The claimant wasn't.
Suppose she'd met you halfway and declared, as the rules stand, on the whatever it was, the December when she gave her judgment, this order is not enforceable.
That would, in a sense, have met the mischief, because
We said she could do that if she wanted to, but it would be rather pointless.
I haven't.
I'm so sorry.
That would have, in a sense, have gone some way to meeting the mischief, because it would have contained a bar on enforceability.
On the rules as they then were.
As on the rules as they then were. But, and this is the but, it then means that the judge is working in the wording, in the thought in her process in her judgment, that the order could shift and mutate if the rules then change. Now, that's not the way it works in any context, my Lord. The court always decides the case on the law as it stands, whether it's substantive law, procedural law, or whatever.
One other question. Does anybody have a figure for what these costs actually amounted to? What were the defendants' approximate costs between
They were in the region of
February and November?
They were about 80,000, I think.
So when they offered your client 800, you could have said, well, actually, we're prepared to take 750 if you agree not to enforce your cost order.
Well, I think that leads me to the further point. The first point is that we would then have been conceding enforceability, albeit on the basis of a pragmatic deal. But as at the Adelakhan case, it was extremely clear what the law was. The law was settled. Now, Adelakhan, as Lord Briggs says later in his judgment, people may think that the decision is, goes too far in one particular direction. But that's a matter for the Rules Committee to address subsequently, as these are matters of policy. The Supreme Court in Adelakhan was concerned with what the rules meant in their then incarnation.
Could I just to complete my note, is the figure of approximately 80,000?
Yes.
Thank you. And so far as just taking the narrative forward, is there a crystallised figure for the costs of your application made to the judge?
Yes. Can I just turn my back and I will just take instruction. Yes, it was just under 12,000.
Something for the defendant's costs as well on that, which you were ordered to pay.
The defendant's cost schedule, I think, was higher than the claimant's at that point.
And I'm just reflecting on the fact that for the risk that you took, that one day you might be ordered to pay 80,000, we're now well north of £200,000 of costs arguments.
In relation to that, I think there are two particular points that I would make. The first is that these all flows from the fact that the defendants were looking for a way to circumvent the effect of Cartwright and Adelakhan, and they took the view that they might benefit from a prospective rule change, which in its terms was retrospective, and so they were prepared to run the point.
Well, you say, I mean, there are two ways of looking at this. I mean, you woke this dog that otherwise wasn't barking by raising the point in the first place. You said, assure us of this. And they said, no, we won't. I mean, they didn't say anything about it. Who knows whether it might have arisen or not?
Well, in relation to that, I think it's fair to say that what Mr. Tabbitt wanted and what I put forward on his behalf, the certainty and finality that his case would be decided on the law as it stood at the 1st of December. I did not want the situation where my client, who was very badly injured in this case, has been given substantial damages but they have to last him the rest of his life, received a letter 18 months or 2 years down the line, putting forward some argument that the rules were in some shape or form retrospective, and in some shape or form he was liable to enforcement. Mr. Tabbitt was entitled to have his case determined on the 1st of December as the law then was, and for the certainty and finality as it then should have been.
But that really builds into the argument, I beg your pardon, the proposition that my Lord Justice Peter Jackson has been putting, namely when settlement is agreed, if what really is sought is finality for an injured claimant, that is the time to use one's best efforts to achieve it. And there is pragmatism in that.
Yes, and attempts were made to achieve that because the application was only made after substantial correspondence when attempts were made to agree the order. Now, the position that the defendant took was that they were not prepared to agree an order in the terms that were sought.
But they were locked into the 800,000 by that point.
Yeah. They were locked into the 800,000.
Yes, I mean, you followed the point.
Yeah, I do. But the point here is that the costs position was significant it needed to be tied down. The position was that the costs should not have been enforceable against my client. There was the issue of the extent to which they're paid is properly part of the cost order. And we come to this point of practice, which is this. If you have a situation whereby the enforceability of an order, which, as at page 40, is otherwise plain on its face, requires you to go to a second source, civil procedure rules, and to know other facts, such as the date the proceedings were issued, then one runs into the situation that the order doesn't mean what it says on its face to anyone who comes across it. And that is inimical to the efficient administration of justice. I think most of the points that I wanted to raise in relation to the grounds of appeal have been dealt with in argument and by questioning from the bench. But there are a number of points that I really wanted to draw together. The court, I think, has got all my points, that Section 51 brings in the QOCS rules. Therefore, they bring the QOCS rules into the judge's discretion. And this isn't a case where the claimant was fundamentally dishonest or brought a mixed claim or any of the other exceptions. So there was no basis for any enforceability of the order. There was only one right order, as the QOCS provisions were absolute. My Lord Justice Jackson has also already dealt with the fact that the point initially taken by the defendant was not a good one, namely that the court had no power because of Part 36. But as I say, there is authority after authority after authority. Three authorities I've taken you to: Parr and Smith, Wagoner, and the Harrison case, where issues of enforceability are dealt with in the order, because otherwise the order would be unqualified in terms of its enforceability. And on 44.14.2, which is this rule about the timing of enforcement, in my submission, that's got nothing to do with the actual point the judge had to grapple with. It's simply dealing with the timing as to when the costs are going to be paid or collected through the enforcement process. It has nothing to do at all with the principle as to whether those costs are enforceable or not. And one could look at it another way. And I'm mindful of what my Lord Justice Lewison put to me, that you don't deal with everything necessarily that might happen thereafter in the order. But the distinction in this case is that the extent of payment is expressly referred to in Section 51.3. And the very final point on the grounds is that where the judge takes into account for not making an order the prospect that the law might change, in my submission that has to be an error of law. It is so fundamental to the administration of justice that the cases are decided on the law as they stand. So, drawing just a couple of points from Mr. Marvin's skeleton argument, in my submission, the fundamental point which underpins all his cases is the notion that you look at the order and the rules side by side in order to interpret the order. And you've got that. But also, this appeal isn't academic. It was wrong in principle to make this order. It remains wrong in principle. And this could all have been avoided had acceptance been made of what the position was on the law by the defendant as at the 1st of December. Those were the points I wanted to make in submission. Does the court have any questions?
No. Thank you very much, Mr. Hogan. Yes, Mr. Marvin.
My lords, my lady, I say that the judge was right for the reasons the judge gave. Just very briefly, by way of context, I think your lordship and your lordships and your ladyship have this. Damages agreed, the incidence of costs agreed. This was a case where there was a late acceptance for Part 36 offer. The claimant accepted the usual principle that he would have to pay the costs from the expiry of the relevant period. There was no attempt by the claimant to say there was any particular reason why that was unjust. So all that was agreed before it got before the judge. It came before the judge in circumstances where the claimant wanted a declaration that the costs order in favour of the defendant could not be enforced. We opposed that, and it was common ground before the court that as a matter of discussions and minutes in the public domain, there was a proposed rule change, which those new rules would mean that we could enforce. I understand that might seem a bit harsh to the claimant, but there is a good policy reason why when a Part 36 offer is accepted late, there should be a sanction. I don't think I need to labour that point. And no one suggested, and so the reality before the judge is there was a very real prospect that there would be a rule change. I underline the next point, which applied to this claim. And we said that, but it's with respect tolerably obvious that the claimants had exactly the same view, and one doesn't need to do much reading between the lines to see the very reason they were insistent on getting the declaration they wanted was because they foresaw the prospect that there would be a rule change which applied in this claim. Now, we now know because of the transitional provision that the rule change doesn't apply, but nobody knew that before the judge. And indeed, it's pretty obvious both parties anticipated, at least potentially, that the rule change would apply. So all the judge did, and I say this was entirely unremarkable, is she said, I'm not going to make a declaration that tracks the wording of the existing order, because there might be a rule change which the rules intend to apply to this case that would falsify that declaration. So I'm not going to do it. And you will have the rule, and it will say what it says, and the transitional provision, if there is one, will say what it says, and you will simply apply the rule. And I say there can be nothing wrong with that. Something else, there would have been no point in this, but something else maybe the judge could have done. I'm not saying it was suggested to her, but I make this point forensically. If the judge has said, well, let's see what the actual new rule says, I'll adjourn this hearing for 6 months or 3 months, who could have complained about that? So I say that the judge's approach was obviously right. And if the judge had gone along with what the defendants wanted, you could have had the obviously wrong situation, that there was an order in this case that the defendant couldn't enforce, but there was a rule that applied in this case that said that the defendant could enforce. That would have been the error, if there was one, in the judge's approach. And incidentally, just to deal with this spectre, that what I'm saying is that defendants could have gone back years and tried to enforce orders. Well, only to the extent that the rule committee allowed that. If the rule committee said, let's suppose instead of no transitional provision, there was a transitional provision that said that this new rule applies where the settlement is after May 2022. I just take that date because that was the date of the government consultation. Then if that's what the rule said, that's what would have applied. So all we were really saying to the judge was that the judge should not preempt a rule change which the rule committee intended should apply in this case. And I say that the judge was obviously right not to make the declaration. And that this appeal really rests on two fallacies. The first is the rather bold proposition that the rules do not have their stated effect unless that effect is stated in a court order. And I say that is demonstrably wrong. The rules apply whether or not their effect is dealt with, is recorded in a court order. And the second fallacy is that the judge simply had no choice but to address enforcement when the judge made the costs award. I will come on to this. I say that's wrong in principle, but it's a particularly weak point where, on the facts here, the judge wasn't being asked to decide the costs in principle. The most the judge was being asked to do was to make a consent order in that regard because the parties had agreed the costs in principle. So actually no issue of principle actually fell for active decision by the judge at all. And so turning to the question whether the effect of QOCS needed to be stated on the face of the rule, or otherwise it would not have its intended effect. That is wrong, as my Lord Justice Lewison said. Enforcement as a general matter is down the tracks from the award in principle, and there can be no general proposition that a court order has to, an order for an award, whether it's damages or costs or anything else, has to address the issue of enforcement.
Could you I'm sure this is just for my benefit, but talk through what would have happened? Let's suppose there had been a trial, and there had been any particular outcome that you care to choose, and this sort of issue had arisen in relation to enforceability of costs. How would it have worked out if the judge had actually been the author of the outcome?
If the judge had made an order at trial, there would have been no requirement for the judge in that order to address enforcement. The judge claim dismissed or
Yes.
Damages for such and such. It would have been possible if some issue as to whether or not enforcement was raised before the judge, for the judge to hear argument on that and make a decision. And if I can, all the cases you've been shown by my learned friend are all cases where there has been an argument before the judge about how QOCS applies. I mean, the example my Lord Justice Lewison took, whether or not a claim is fundamentally dishonest, because if the judge finds it's dishonest, fundamentally dishonest, that disapplies QOCS. And if the judge, after trial, is invited to deal with that, one would expect a judgment and the judge's decision to be recorded in an order. In the appellate courts, again, the decisions are where there has been an issue. They've tended not to be fact issues, they've tended to be law issues. Upon its true construction, what does the QOCS regime permit? Can you enforce against costs? Can you enforce against settlements? Answer on the old rules that we're dealing with, answer no. Answer on the new rules, although there's no authority.
But your point is that even had the judge been the author of the outcome, she would not have been obliged to deal with enforceability, but she could have done.
She could have done. But there's all the different. I mean, so there are cases, I accept.
I mean, go back to the example of the fundamentally dishonest claim. Claimant brings a claim, judge says, I dismiss this claim, and in the judgment it is said, this claim is fundamentally dishonest, I am going to order the claimant to pay the defendant's costs.
Yes, and I disapply QOCS.
That's all that the judgment needs to say,
Yes.
isn't it? You then say, well, can that be enforced under the rules? And you look at QOCS and you say, well, the judge has found this was fundamentally dishonest, therefore I can enforce.
So, yes, my Lord, yes. And so there will, but even if it goes in the order, I'm not saying you can never or should never have an order where the effect of QOCS is recorded. Sometimes it might be sensible to do, so sometimes it might be sensible, particularly if there's been an argument about the effect of QOCS. But there's all the difference in the world between an observation that sometimes an order will record what the effect of QOCS is, and I have no difficulty with that. But that is completely different from a proposition that unless the order says what the effect of QOCS is, the rules effectively do not apply. I say that that is obviously wrong. And and incidentally, but my learned friend says he's not giving evidence, and he's not, I'm sure. But this court will see decisions where such orders have been made. But that's because the court is looking at decisions where there's been an issue as to what the effect of QOCS is. I'm told, and again, I'm not in a position to give evidence, that often, perhaps just because it's absolutely obvious that it's a personal injury claim, etc., that the order doesn't record the effect of QOCS. And if my learned friend was right, then the spectre of defendants going back and trawling arises on his argument. If his argument is right, then subject to limitation periods on enforcement, defendants can go back and have a look at all the QOCS cases where unenforceability was not recorded in the order and seek to enforce, and that would be an extraordinary position. If QOCS applies under the rules, sometimes it might be recorded in the order, but it does not need to be recorded in the order. And there's just one other example I would like to give why that just must be right. There will be court orders, and indeed the one that the court saw in the supplementary bundle at page 40 is an example where the defendant is awarded interim costs. And at that stage, you don't know whether that order can subsequently be enforced, because it will only be at the end of the matter that either QOCS might be disapplied because it's a dishonest claim, or, on the other hand, the claimant is awarded some damages against which a defendant's cost order can be enforced, and under the new rule, it can also be enforced against a damages settlement or costs. So one of the very typical situations in which the defendant has an enforceable cost order is where it gets an interlocutory order, and it's only either if subsequently QOCS is disapplied, for example, because the claim is found to be dishonest, or on the other hand, the claimant is awarded damages and therefore or costs, and therefore within the QOCS framework, there can be enforcement up to those awards, that enforcement can be addressed. So it cannot be right to say that enforcement has to be dealt with in the order that awards costs, because there will be, the obvious example being interlocutory orders in the defendant's favour, there will be cost orders where you don't know until you know how the claim turns out whether the defendant will be able to enforce or not. And I just wanted to make one...
That doesn't really meet Mr. Hogan's point, does it? I mean, his point is not that this was an interim order, but this is a final order, he says.
Yes, but well, it meets the point in my submission that the order needs to say on its face whether there can be enforcement or not. It meets that point, because there are examples where you don't know whether in the future the order will be enforceable. It depends on the issues I just mentioned. I just wanted to make one, but I accept that it doesn't go further than that. I just wanted to make one point in respect of the suggestion that all this is part of the Senior Courts Act, Section 51, and the powers the court has to award costs, and therefore it all needs to be dealt with in one go. There's a point in the background that I see in my learned friend's supplementary skeleton argument that the power for the QOCS rules is Section 51 of the Senior Courts Act. That's not right, and it's not what Wagonar says. What Wagonar says, because the challenge in Wagonar was that the QOCS rules were ultra vires because they offended the provision in Section 61 that gave the court a total discretion, etc. And that was rejected by the Court of Appeal. So the QOCS rules are not ultra vires by reason of offending Senior Courts Act Section 51. But that's not the same as saying that the vires, all the power for the rules, is Section 51. Section 51 says, subject to the rules of court, the court has discretion. But that is not the basis on which, that's not the jurisdiction of the Rule Committee to make rules. The jurisdiction of the Rule Committee to make rules is the Civil Procedure Rules Act 1997. And that's the power under which it makes rules. And although that's a point in the background, I just make that point because it's, as I understood it, I listened to my friend, uses a bit of a footing for saying that because this is all covered by Section 51, you have to deal with it all in the same order. Section 51 is in essence concerned with awards of costs in principle, and that's conceptually distinct from enforcement, whether it's costs or damages, which as a general matter is a downstream consideration.
Depends what you mean by payable, the extent to which they are payable.
Yes, yes, payable, but subject to the rules of court that say it can't be enforced. And just as a general matter, it's not unheard of for enforcement. If it went the distance, there was nothing in the rule a defendant tried to enforce, and a claimant said, you can't enforce this rule because the QOCS rules are a bar on enforcement. At that stage, someone would have to make a decision. But this, in the context of enforcement, it's not unheard of for investigations and decisions to have to be made. For example, if there's enforcement, the debtor might say, well, I want to set off, and someone would have to make a decision about that. Or a debtor might say, well, actually, I've already paid this, in which case the court would have to inquire into that. So it's perfectly possible as a general matter for decisions about decisions as to whether or not enforcement can happen to be made at the stage where enforcement is intended.
Well, a typical case would be where someone goes bust.
Yes.
So you can't enforce it.
You can't enforce it against me. I have
my bankruptcy.
Well, yes, you have to. You join the queue and get 10 pence in the pound, not the 100 pence in the pound that you want. And so that's the first fallacy that well, in fact, that is the fallacy that enforcement has to be addressed at the same time as the award in principle. And I've made submissions that already to the effect that it's wrong to say that the rules don't apply unless their effect is recorded in the order. The effect might be recorded in the order. Often it will be sensible, but even if it isn't, the rules have their own force and they do apply. On the principle of finality, that's dealing with a separate issue. That's dealing with where the court makes an order deciding something and the limited circumstances in which it can revisit it. Where the court hasn't ruled on enforceability, it does not offend the principle of finality for the court to do that on a subsequent occasion. So, and also, I just wanted to deal with the suggestion that the debt under a judgment can be essentially that it can be factored and you might have a third party seeking to enforce. That doesn't create a problem. That third party, if a debt is factored under a court order, would be subject to the rules of court. The assignment, the right that's assigned can't be any greater than the right which an enforcing party has. And of course, in the real world, this factoring is done by commercial entities who do that for a living, and they will be very alert to the possibility in a personal injury case that they might have to grapple with QOCS. So, in sum, I say that the judge was right for the reasons she gave, but it cannot be right to say that she was right, that dogmatically, that she had that she was simply not entitled to decline to make a declaration in circumstances where there was material before her that might falsify that declaration. And so ultimately, that's what this appeal is about, and the judge's reasoning in my submission can't be impugned. My lords, I've taken that, I hope, in a relatively efficient way. Unless there are any questions that the court has for me, those are my submissions.
Thank you very much, Mr. Marvin. Mr. Hogan, do you wish to reply?
Yes, very briefly, my lord. My lord, in paragraph 10 of the supplementary skeleton argument I put forward, I deal with the reason
Right,
why...
just a minute, let me just get it. Your supplementary.
I'm obliged.
Yeah, paragraph 10.
I deal with the reason why the suggestion that there were going to be retrospective provisions in the QOCS rules were unrealistic, because in essence, ever since the QOCS rules were brought in, there were transitional provisions. There was
Yes,
a cut-off.
we know that there were then and there are now.
The second point, which flows from that, is that, as I say, we come back to the fact that there is, in a sense, a kite being flown by the defendant, which started this whole chain of events. They wanted to leave open the possibility of the double contingency that the rules would change retrospectively in their favour. But they run again into the impediment of the principle of finality. And the point being made that the retrospective nature of the rules, if such had been enacted, was something anticipated for by the Civil Procedure Rules Committee, simply underlines the fact that the Rules Committee undoubtedly had considerations of certainty and finality at stake. Mr. Marvin doesn't really deal with the practical consequences of where his line of argument takes him. If it be the case that an order for costs is made against a claimant, which may be a quantified order giving pounds and pence at the end of a one-day fast-track trial, if it's not marked on the order that this is unenforceable because that is the way the court exercises their jurisdiction under the Section 51 as modified by QOCS rules, Mr. Marvin's argument is that when that defendant moves to enforce that order, the onus is on the claimant to make an application to court to stay any enforcement process, to take the judge through the white book and to explain why the order, which says claimant shall pay these costs by such and such a date, actually doesn't mean what it says on its face. And that seems a very long way to go round, as opposed to marking in the order that is made the extent to which they are payable. My lords, those are the points I wanted to make.
Thank you very much. We will retire for a couple of minutes just to see where we go from here. So don't leave the courtroom, please.
God rise.
We'll give judgment at 2:30.